Hello, my name is Fajrina Valkish, and the topic that will be talked about in this video will cover the ownership with regards to copyright, trade secrets, patents, and trademarks. The term intellectual property is ordinarily understood by the layperson as referring to products of the human mind. Its legal meaning denotes the rights which are given by the law to products of the mind. Article 1, Clause 2 of the Agreement on Trade-Related Aspects of Intellectual Property Rights (TRIPS Agreement) states the term of intellectual property. Under the umbrella phrase of intellectual property, it includes patents, copyright, integrated circuits, industrial design, trademarks, private information, plant varieties, and geographical indications. By giving the owner of intellectual property the sole right to commercially exploit the intellectual product for a set period of time in exchange for disclosing it to the public, intellectual property serves the objective of encouraging the development of ideas and technologies. So, is the creator of the intellectual property the owner of the property? Copyright is the exclusive right to control creative works created by the author, copyright owner, and performer for a specific period governed under the Copyright Act 1987. A copyright can also be sold and the ownership transferred to a different entity, which is then the recipient of any recompense from its use and retains sole rights for use and distributions. It is stated generally that the author is the creator of the work under the copyright law, the first owner of the copyright. The copyright in the work may belong to or be deemed to have been transferred to the commissioner of or the employer in certain circumstances, such as when the work was commissioned or completed while the author was employed. As the owner of the copyright, the author is free to assign, transfer, transmit, or issue licenses in relation to all or a portion of his rights. In Yo Ki Aun, the Judge Steve Shim stated that the author of the work need not necessarily be its copyright owner, and in the case, the applicant had not shown full ownership of the copyright in key data services, which led to the ex parte order dismissed. Furthermore, in regards to an employee creation during the course of employment, employees yield valuable intellectual property for the companies that hire them. In Stephenson, Jordan and Harrison's Limited, the court held that because he was hired to advise clients rather than deliver lectures, the accountant owned the copyright to the lectures. However, his employer owned the copyright to the portions of the book that contained reports that the accountant had produced for the clients of his employer. Furthermore, a patent is an exclusive right granted for an invention, which is a product or a process that provides a new way of doing something or offers a new technical solution to a problem. According to Section 18, Subsection 1 of the Patents Act 1983, any person may submit a patent application either individually or jointly with another person. Yet, Section 18, Subsection 2 of the Patent Act states that the inventor has the right to a patent in general, but if the inventor does not make the application for a patent, by virtue of Regulation 10 of the Patents Regulation 1986, the applicant needs to provide justification of his rights to the patent and still include the inventor's name in his request. This relates back to the topic above where the inventor and owner of the patent are two distinct concepts. By virtue of Section 36 Sub 1, the owner of the patent, who is the person for the time being recorded in the register, is the owner who have unconditional right to control the usage of the patent. Having said that, there are some instances in which a third party might have greater claim to the patent, such as inventions developed while the employee was performing their job or commission work. Pursuant to Section 20, Subsection 1 of the Act, the employer or the person who commissioned the work is presumed to acquire the right to a patent for inventions developed while carrying out a contract of employment or completing a commissioned work. This section was applied in the case of Sun Seng Palm Oil Mill, Sdn Bhd in 2011, where it established three requirements for the party, relying to deem the provision in Section 2, Subsection 20, Sub 1, which there must exist a contract of employment or commission work. The inventor carry out activities in the performance of the contract or execution of the work, and there was nothing to contrary that suggests inventor can claim ownership of the invention. Under Section 20, subsection 2, even if the invention was made outside the scope of employee's duties but used the employer's facilities such as the data or means placed at the employee's disposal, the invention is deemed to accrue to the employer, but it must be noted that this only applies to employment contracts, not commission work. The same could be said in the United States, where the inventor keeps the ownership of his patented invention until he willingly transfers it to his employer. But in fact, most inventors are under compulsion to do so because of an implied contract that was established when they were employed to develop a fresh idea. Moreover, moving on to trademarks. Trademarks are names or symbols that a business uses to distinguish its products from those of competitors in order to show that the products and services are linked to the trademark owner. Trademarks may include a firm name, a distinctive packaging design, a logo, or any combination of these. In Malaysia, registration of a trademark is not compulsory. Essentially, the purpose of a trademark is to create in the public's mind a link between the goods or services and their trademark proprietors. Pursuant to Section 25, subsection 1 of Trademarks Act 1976, the person entitled to make an application for the registration of a trademark used or proposed to be used is the proprietor of the trademark used or proposed to be used. In the case of Lim Yu Sing in 1997, the court held that the first person who used a trademark would become the proprietor of the trademark at law, even though he might not have acquired any reputation in the market in relation to the business that used the trademark. Zinatul in her article mentioned that in regard to an internet domain name versus a trademark, there could be a multiple companies that uses Apple as the company name, but only one could have apple.com as a domain name. This shows that one business could legally prohibit another from using the same domain on the internet. Moving on to trade secrets, the last element that will be talked about in this video. In Electrocac Australia case in 1998, confidential information includes everything from personal or private secrets to secrets from business or industry and secrets from the government. It is still debatable whether the law of property may serve as a jurisdictional basis for a law of confidential information because it is not accepted in Malaysian law that confidential information in itself is property. The judge in Electrocat Australia case took the view that it is a property for the purposes of an action for thought of conversion, and this is affirmed in the 1997 case Smith Scientific Sedang Berhad against Ong Han Swan. Without an assignment of the trade secret from the employee to the employee owns the secret he conceives or invents during the employment. There exists the term Trade Secret Protection Procedure, also known as the SPP, that employers implement for their employees to follow while handling employees' trade secret. A famous example for this would be the recipe to the KFC's fried chicken, where the company employ one different company to make part of the recipe and another company to make the other part of the recipe. This is to ensure the security of the recipe and only a handful of people know the complete recipe. Since trade secrets are protected by contractual restriction on use and not by registration, it is not bound by a limited duration of protection like copyright and patent. A trade secret can also be kept in relation to an invention or innovation that does not meet the quasi-requirement of patent law. Conversely, normal mentioned trade secrets can also be used to protect a variety of things that are not patentable or for which there is no copyright protection. Although trade secret can protect ideas as well as expression, copyright law only protects expressions and does not cover ideas. In conclusion, based on the critical analysis above, the creator of the intellectual property does not necessarily be the owner of the said intellectual property. Thank you.